Hello and good evening, all legal enthusiasts. Welcome back to Legal Darpan, your go-to destination for legal current affairs. I am your host Sushila Chaudhary, and today we'll be dwelling into landmark Supreme Court judgment of December 11, 2023, a day that reshaped the constitutional narrative of Jammu and Kashmir. Before we dive in, make sure to subscribe to our channel and hit that bell icon to stay updated on all things legal. Now let's get to untangle the legal intricacies of the verdict on the Article 370. Now, in a landmark decision on December 11, 2023, the Supreme Court of India, comprising 5 senior-most judges, upheld the Union government's move to abrogate Article 370, which granted special status to erstwhile state of Jammu and Kashmir. The court, however, refrained from commenting on constitutionality of reorganization of Jammu and Kashmir into two union territories, Jammu and Kashmir and Ladakh. Chief Justice D.Y. Chandrachud, on behalf of himself, Justice B.R. Gawai and Justice Suryakant, wrote 352 pages of 476-page judgment. Justice S.K. Kaul wrote 121 pages and Justice Sanjeev Khanna wrote a concurring judgment of 3 pages. Now let's dig into the background to understand where exactly the issue stemmed from. Now the hearing regarding the repeal of Article 370 and the reorganization of the state of Jammu and Kashmir began in December 2019, just 4 months after the centre's notification to abrogate Article 370. Despite the judgment acknowledging that a 5-judge combination could address the issues raised in pleas, the matter had not been listed for a very long time. It got listed in August this year. However, it had been mentioned in front of several Supreme Court Chief Justices on multiple occasions, and in April 2022, the then CJ N.V. Ramana declined to provide definitive answers when it was mentioned in September of the same year. Chief Justice U.U. Lalit agreed to list the petitions, but his tenure was short-lived. His successor and the current Chief Justice Chandrachud expressed his inclination to list the matter on several occasions, and hence it was listed to be heard in August, initially in August. And after there were 16 days of hearings that happened. Now the key points of the petitioner's argument included Jammu and Kashmir's unique relationship, the permanence of Article 370 post 1957, and the need for state concurrence of 2019 presidential orders, issues with Parliament's role, misuse of Article 356 and the amendment through Article 367 were raised. Concerns were expressed about the impact on representation, legislative power, and democratic principles of J&K. Petitioners emphasized the transformative interpretation of the Constitution. The abrogation was also criticized as an abuse of power for political gain, questioning the legality of 2019 BJP election manifesto and the government's actions. Now let's dive into, since the Constitution is the heart of the issue, so let's dive into what exactly our Constitution says. So there are two main articles, that is Article 35A and Article 370, that deal with this particular special status issue. Now talking about Article 35A, which stems from Article 370 and was introduced through a presidential order in 1954. Article 35A does not appear in the main body of the Constitution. Article 35A is followed by Article 36 but appears in Appendix 1. Article 35A empowers the Jammu and Kashmir legislature to define the permanent residents of the state and their special rights and privileges. Permanent residents of Jammu and Kashmir were given exceptional privileges and rights under Article 35A, including the ability to purchase property there, preference in hiring for the position in the public sector, and other benefits. According to this article, only citizens of Jammu and Kashmir who dwell there year-round are eligible to purchase real estate and cast ballots in the local election. Article 35A was repealed by the Jammu and Kashmir Reorganization Act of 2019. Now coming at the main article that we've been talking about, Article 370. Now Article 370 is a constitutional provision that gave Jammu and Kashmir its special status. The signing of the instrument of accession by Maharaja Hari Singh in 1947 led to the creation of Article 370. The provision was incorporated in part 21 of the Constitution under the heading Temporary, Transitional and Special Provisions. This article, enacted on October 17, 1949, as a temporary clause in the Indian Constitution, granted Jammu and Kashmir exemption from certain provisions of the Indian Constitution. It restricted the Parliament's legislative powers with respect to the state of Jammu and Kashmir, and it allowed the state to have its own constitution, limited the legislative authority of the Indian Parliament in the region. Initially proposed as Article 306A by Sir Narasimha Gopalaswamy Iyengar, it eventually became Article 370. Now, after the Jammu and Kashmir Constituent Assembly created the state constitution, it dissolved on January 25, 1957, without endorsing either abrogation or revision of Article 370. This left the status of the clause uncertain and subject to interpretation. Now, this particular article has been part of the discussions and debates for a very long time, since Pandit Nehru, on the floor of Lok Sabha on 27 November 1963, said that the Article 370 has been eroded and the process of gradual erosion is going on. A year later, the then Home Minister Gulzari Lal Nanda, again on the floor of Lok Sabha on December 4, 1964, said Article 370 is a tunnel to take the Constitution of India to Jammu and Kashmir. He further said that in the end only the shell will remain there and it will benefit of its contents, and it will hardly make any difference whether it's kept or not. These two statements by two tall leaders of the country speak volumes about the dilution of Article 370 of the Constitution, was just merely after 1 decade of its enactment. Now, talking about the abrogation, which was actually challenged, was done in 2019. The President of India utilized the authority provided by Clause 1 of Article 370 to issue Constitution implementation to Jammu and Kashmir Order 2019 on August 5, 2019. This order revoked the special status that was previously granted to Jammu and Kashmir. As a result of the repeal of Article 370, Jammu and Kashmir no longer possesses its own constitution, flag or anthem. The population of Jammu and Kashmir no longer holds dual citizenship. The legislative amendments made by the Indian Parliament, such as right to information and right to education, are now applicable in Jammu and Kashmir. With the abolition of Article 370, Jammu and Kashmir now comes under the full purview of the Indian Constitution and all 890 central legislations that we have. After the repeal of Article 370, Jammu and Kashmir is considered an integral part of India, both legally and practically. The view was that the Article 370 of the Indian Constitution was a temporary provision that lacked the effectiveness and thus needed to be repealed. Now, let's dive deep into the key points of this verdict that was given. Now, there were 4 key points that have been talked about. So the sovereignty is one thing that Justice D.Y. Chandrachud talked about. So while delivering the judgment, he emphasized a proclamation by Yuvraj Karan Singh in 1949 asserting that the Indian Constitution would govern Jammu and Kashmir's relationship with India. The Chief Justice contended that this proclamation negated clauses in the instrument of accession and argued against J&K retaining sovereignty. The Chief Justice then argued that the Article 370, being a temporary provision, did not gain permanency due to the Constituent Assembly's dissolution. He highlighted that the provision aimed to address special circumstances in the state, ensuring the integration with the Indian Union. The judgment clarified that the President's power under Article 356 during President's rule, stating that not every decision could be subject to judicial review. The court outlined criteria for assessing the grounds for such review, emphasizing a reasonable nexus to proclamation and objective. The court also declared that Constitutional Order 272 or CO 272, amending Article 367 to replace Constituent Assembly with Legislative Assembly, was invalid and unconstitutional. However, it deemed that the overall order valid, asserting that the President's power to apply the entire constitution to J&K. Now, regarding the constitutional order of 273, which declared the cessation of Article 370's operation, was deemed valid by the court. The court found no malicious intent and stated that the President's decision was subject to review only if malified intentions were proven. The verdict held that the entire Constitution of India will, following CO 272 and CO 273, applied to Jammu and Kashmir, rendering the state's constitution inoperative. Justice Kaul, in the concluding note of his written judgment, recommended the establishment of a Truth and Reconciliation Commission to address human rights violation in Jammu and Kashmir, emphasizing the importance of reparations and transitional justice. The J&K Reorganization Act 2019 was deemed procedurally valid, but the court left open the substantive question of whether J&K lost its character by becoming two union territories, emphasizing the assurance of J&K's statehood restoration. The court also in this case directed the expeditious restoration of J&K's statehood and called for legislative assembly elections before September 30, 2024. This historic verdict marks a significant development in the legal and constitutional landscape of Jammu and Kashmir, concluding a prolonged legal battle over the abrogation of Article 370. And there you have it, a comprehensive breakdown of the Supreme Court's monumental verdict on Jammu and Kashmir. If you found this exploration insightful, don't forget to give it a thumbs up, share it with your fellow legal eagles, and comment below with your thoughts. Remember to subscribe and hit the notification bell to stay tuned for more legal insights. Until next time, I'm Sushila Chaudhary signing off from Legal Darpan. Stay curious, stay informed.